All rise. First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Hi. You may be seated. We are here for one case, Wallace versus State. Is the appellant ready to proceed? You may.
May it please the court, my name is Justin Karp and I represent appellant Mr. Wallace. I'll reserve 5 minutes for rebuttal. Question for this court is who the principal prosecuting attorney of the state of Florida is. The two contenders for this title are the Attorney General and the statewide prosecutor. Because the Attorney General is the chief legal officer of the state, the Office of the Statewide Prosecutor is a separate budget entity within its office, and the Attorney General appoints and can fire the statewide prosecutor. The Attorney General is the principal prosecuting attorney of the state. So federal law 18 U.S.C. 2516 subsection 2 authorizes two state-level prosecutors to apply for a wiretap: the principal prosecuting attorney of the state or the principal prosecuting attorney of any political subdivision thereof. The state is essentially asking this court to rewrite that statute, but Congress specifically used the singular attorney. The Florida Supreme Court recognized that federal law preempts state law for wiretaps decades ago in Rivers. Principal isn't a legal term of art.
Counsel, let me stop you there before we get to whether the statewide prosecutor is a principal prosecuting attorney. Looking at Section 2516, it says that the principal prosecuting attorney can apply for an order authorizing a wiretap in conformity with Section 2518, correct? So I was wondering, where is actual authority to suppress information that is obtained from wiretap? And it's in 2518, in subsection 10. It says an aggrieved person may move to suppress on the grounds that the communication was unlawfully intercepted, the order of authorization was insufficient on its face, or the interception was not made in conformity with the order of authorization. Which of those provides the basis for suppression in your case, or are you not relying on the federal statute?
I am relying on the federal statute. It would be unlawfully obtained if the application was signed by an attorney who is not.
It doesn't say unlawfully obtained anywhere. It says insufficient on its face. Where in the face of the order authorizing the wiretap does it demonstrate that it's insufficient on its face?
I think it is facially insufficient if it is approved. If it is approved by somebody who is not authorized to approve it. It is.
The judge isn't authorized?
Well, if the attorney who submits the application to the judge. So here, if it's.
So how is the order insufficient on its face if the person who sought the authorization was the wrong person? I mean, that strikes me as a technical defect, and the way that we normally look at these in warrant situations is four corners of the order. So what is it about the order from the judge that is insufficient on its face?
It's how the order got to the judge. The order itself, if the proper attorney had signed off on it, there may not be a problem with the order at all. The problem is how it got there. And as for the four corners, I think that's really getting a little bit more into the remedy as opposed to.
Well, suppression is the remedy, and those are the
Correct.
grounds for suppression.
Right. But I mean, I think it's just we want strict compliance with the statute. Congress and the Florida legislature have both said that suppression is the remedy if the warrant is, or if the application that leads to it is improper.
Okay, but the statute does in fact state those as the grounds for suppression, so it falls under one of those, is what you're saying?
Correct. I'm not disputing what the federal statute that control says.
Can I take you back to something before the statute also, and the parties don't really talk about this much, but has the appellant, and I know the public defender wasn't trial counsel, but has the appellant properly reserved his right to appeal this as a dispositive issue? The plea form and the record of the plea colloquy both seem to have an affirmative waiver of the right to appeal. And the judge even asked him about Judge Hawk's opinion in the other case, in the Roberts case. So, I mean, I know there's a filing 2 weeks later on dispositiveness, and the state stipulates But, I mean, that's 2 weeks afterwards, and that seems contrary to the plea agreement. So is this even properly before us?
I would argue that it is. I think as best I can tell from the record, it was an inadvertent error. Defense counsel spoke with the prosecutor, The prosecutor agreed that it was dispositive at the time it was entered. I think it was.
Well, but isn't the way to fix those inadvertent errors a motion to withdraw the plea? You go back in and go, Judge, wait, time out. We forgot. We got this whole suppression issue that we want to argue in the DCA. So we want to take this unconditional plea away. We want to enter instead a plea with this reservation.
Right.
I mean, wouldn't that be the better way to do it?
Generally speaking, I would agree that's the better way to do it. I think the judge understood what was before him at that sentencing hearing when they clarified it. I guess they could have gone through that procedure, but I think just in the interest of time, when the judge realized that the parties agreed that it was intended to be reserved and dispositive, that the judge just accepted that stipulation rather than withdrawing the plea, re-entering otherwise the same plea with that stipulation, and the state didn't argue that it wasn't preserved on appeal. I think it is properly before this court with those stipulations.
Is a defendant required to reserve an issue for appeal at the plea hearing?
Generally, yes. I don't think it's in dispute that that was an inadvertent error that was corrected as soon as it came to light, was placed on the record before the court without objection from the state.
Go into the substance of your argument. There's two clauses there in 182516(2), principal prosecuting attorney of the state or principal prosecuting attorney of any political subdivision. The judge here relied on the first clause. The judge in Rogers on the second clause. Do we need to analyze the second clause? And if so, is our analysis any different than what the panel did or is doing in Rogers?
I don't think this, because Judge Allman was very clear that his specific ruling was that the statewide prosecutor was the principal prosecuting attorney of the state. I think everything he said about the political subdivision was dicta. I've watched the oral argument in Rogers. I think it's a little bit of a different posture there. I know it was a state appeal, so the defense was really talking more about preservation than the substantive analysis, but I do think Judge Hawk's order in Rogers, as discussed in the briefs, does have the correct analysis that the Office of statewide prosecutor isn't the principal prosecuting attorney of a political subdivision either, but before this court is only, I think, that first one of the state.
Could we affirm the order on the basis of the political subdivision argument?
I mean, under the tipsy coachman doctrine, nothing stops this court, but I think general principles of appellate review is Judge Allman's specific ruling was that the principal prosecuting attorney of the state was the statewide prosecutor. That's squarely before the court in this appeal. The political subdivision issue, I think, is more squarely before the court in Rogers. And principal is not a legal term of art. Merriam-Webster defines it to mean one who engages another to act as an agent subject to general control and instruction, and it also provides that a principal is the person from whom an agent's authority derived. So the Florida Constitution lists the Attorney General as the chief state legal officer, and it was later amended to include the Office of the Statewide Prosecutor in 1985. The commission that led to the statewide prosecutor's creation specifically omitted the wiretap authority. And if you look at the structure of Florida's government, in addition to that language in the Constitution about the chief legal officer, I think that can most fairly be read as the highest attorney in state government. Chapter 16, which is titled the Attorney General, contains the Office of the Statewide Prosecutor, which is listed as a separate budget entity within the Department of Legal Affairs. That chapter also provides that the AG shall appear in and attend to, on behalf of the state, all suits, prosecutions, civil or criminal, in the Supreme Court or this court. That's subsection 4. Subsection 5 is in the trial court. And in addition to the statewide prosecutor being within the Attorney General's office, the Attorney General picks the statewide prosecutor, can fire them at will, and can act in their stead in the event of a vacancy. And the statewide prosecutor can't do any of those for the Attorney General. If the Attorney General is unable to perform their duties, either the Attorney General themselves or the governor appoints an acting Attorney General. So when the dispute between the parties below was whether the principal is either the Attorney General or the statewide prosecutor, and one of the contenders for principal can just fire the other. I think the principal has to be the one that can do
But
the firing.
even if we agree with you on the textual argument, why doesn't U.S. v. Leon apply? I mean, this seems like a pretty classic good faith exception. There's a Florida statute that gives the statewide prosecutor this authority. No court has said that the statewide prosecutor doesn't have this authority. If we're the first ones to say that he doesn't have this authority, why is there not a good faith exception that's applicable here?
That's because the good faith exception is a judge-made doctrine, and both the Florida and the federal statutes say that the remedy is suppression on this issue. So I don't think this court needs to reach that exception when the legislature has been clear. I see that I'm into my rebuttal time. I ask that this court.
Thank you, counsel.
Good morning, Your Honors, and may it please the Court, Alan Huang for the State. My friend begins by saying that there are only two contenders for respectively the principal prosecuting attorney of the state and of a political subdivision, and that for the principal prosecuting attorney for the state, it can only be the Attorney General. As a textual matter, in 1968, every state had the position of the Attorney General. So Congress wanted to specify that that position only could be the principal prosecuting attorney of the state. It could have done that, but instead it chose a broader and more capacious term, conferring flexibility on the states to decide who can approve wiretap applications at the state level. And the Florida Supreme Court, the 11th Circuit, and at least one other highest court of the state interpreted the text reasonably to be about centralization and political responsiveness. And the statewide prosecutor meets those criteria. At the state level, he is a person in whom the power to investigate and prosecute crimes is vested. If one looks at the vast powers that he has in Florida Statute 16.5.
The principal prosecuting attorney, that would normally be read as singular, right? The meaning only one person has that authority, and that seems pretty clearly to be the Attorney General, who is under the Constitution the chief legal officer of the state.
Well, Daniels explained that what matters is that the power is vested in a narrow class of officials, and Vespucci, the case from New York, builds upon the idea that it could mean that there could be more than one principal prosecuting attorney of the state. Now,
Does the Attorney General have authority to prosecute beyond the authority that's granted the statewide prosecutor?
I mean, the Constitution or the statutes say that generally she appears in criminal cases, but in terms of like the function of
So she can actually prosecute?
the function of prosecution is vested in the statewide prosecutor and at the local level the state attorneys and in some cases the municipal attorneys. So
Is that a no? Other than the statewide prosecutor, the Attorney General does not have any independent prosecutorial authority?
no, besides the mention that she appears in cases
So her
generally,
only
but
prosecutorial authority is through the statewide prosecutor?
at the state level, it is a statewide prosecutor who is the prosecutorial authority for the state. To continue, as I mentioned, he meets the criteria of centralization and responsiveness to the political process. He decides wiretapping at the state level so that the state's practice on that is applied even-handedly, and if that power is misused, the lines of responsibility run only to him and from him directly to the elected Attorney General, who appoints him, and his term runs concurrently with hers, and he can be removed by her if he abuses the wiretapping authority. So that makes him responsive to the political process. So what the defendant has suggested is what he might call textualism, but it more veers into a narrow formalism that doesn't recognize the inherent flexibility that's suggested by the words. And we think that it just can't be that the Congress intended for someone like the statewide prosecutor who has vast powers to prosecute and investigate cases that he would be
in
precluded.
the first clause, though, 2516.1, a number of deputy principals are designated. So if Congress wanted to give the solicitor general, the statewide prosecutor, the chief deputy assistant attorney general, whoever down the line, couldn't Congress have just spelled it out like they did in paragraph 1?
Sure, but I think Congress understood that each of the 50 states have different schemes, and instead of spelling it out, it used a broader, more capacious term to let states decide how to structure their prosecutorial systems and how to carve out the different roles.
Counsel, the second clause in 2516 sub 2 says, if such attorney is authorized by a statute of that state to make application for an order authorizing. Do we consider that clause at all? Or do we only consider whether the statewide prosecutor is a principal prosecuting attorney?
It's both, Your Honor, and I don't think there's any.
So what effect does that second clause have on it, since it says if?
Well, it gets us past the easier issue in that no one contests that the statewide prosecutor is enumerated in Florida Statute 9034.07, and then so here we're just focused on whether that position is in conflict with federal law, and we're arguing that it's not in conflict. I'll go on next to the political subdivision argument, and here I think we can start by discussing what the term political subdivision means in the context of Title III, and the context would suggest that it's not a political subdivision in the strict traditional sense like a city or a county, and that it takes on the more general meaning of a division of the state that exists to carry out some function, and that function here is prosecution. And just as a state attorney has his political subdivision, so to speak, the judicial circuit, the statewide prosecutor necessarily has his, and that is the multiple circuits in which a crime has occurred or where its effects are felt.
The Rogers panel is dealing with that, presumably. Is there anything here that's different than what they're dealing with?
In terms of, as to the political subdivision argument?
Political subdivision argument, right. I mean, this is the same argument that you made there, right?
Right. This second part of the argument here is the argument that we made there,
right.
But we believe that this court can first affirm on the principal prosecuting attorney of the state grounds that Judge Ullman ruled on, and then the alternative can reach, if the court disagrees with us there, can decide on the political subdivision.
Can I ask you the same question I asked your worthy opponent there? Is this properly before us? The plea agreement didn't have, specifically actually waived the right to appeal, didn't say anything about reserving the right to appeal, dispositive motion for suppression. The plea colloquy, same thing, and then 2 weeks after that, we get this one-page stipulation that this is dispositive. Is this properly before us? Is it the state's position that every defendant in every case is going to be able to, 2 weeks after a plea, file a reservation then?
No, but just based on my limited understanding of the procedural posture below, as I understand it, the state worked with the defendant and stipulated to have this issue being reserved.
So is it the stipulation that makes that reservation valid and properly before us, or can any defendant reserve a dispositive motion sometime after the fact, so long as the time to withdraw the plea hasn't run? I mean, how long after the fact can a defendant make that reservation?
No, but I'm not prepared to really go into the substance of that. I'm just based from what I learned that there was a bit of a delay, but the state just didn't just stipulate it and did not object to this.
I mean, normally most objections have to be contemporaneous, right? I mean, like I couldn't 2 weeks after a trial say, oh, by the way, I want to object to that hearsay that came in, right? So, but something is different about this that allows the objection to be filed after the fact?
Generally not, but like I said, based on my limited understanding, just in this matter, the state did not. The state.
I know the state would like us to reach the ultimate issues and not deal with that. Can I ask you back then to the ultimate issues on the U.S. v. Leon and good faith exception?
Yes.
Assuming we agree that the special prosecutor did not have authority under the federal law to seek these warrants, why wouldn't I'm sure your position is it applies, but they say that there's a statutory reason that it doesn't apply. What's the response to that?
Sure. Well, it's an open question for the Florida courts, but of all the federal courts that have decided the issue, all of them, except one, have reasoned that it makes sense that if suppression is a remedy, a statutory remedy, that it makes sense that the developments in the good faith have to do with that are kind of considered and imported into that. If the court has no further questions, we'd ask the court to affirm the circuit court. Thank you.
Rebuttal?
Just a few points on rebuttal to clarify what may have been miscommunication. Saying that there's only two contenders, I meant here under the posture. The dispute before Judge Allman was who the statewide prosecutor was. I recognize the statute says that there's the principal of the state and the principal of the subdivision. So to the extent there was any confusion there, I meant to characterize only the dispute before Judge Allman as to who the principal for the state was. I think the state was mentioning the Vespucci case, and certainly every state is going to have a different structure as to who the top attorney is. I think this is very much what Congress meant when it said the principal prosecuting attorney of the state is they were not concerned with title. They were concerned who is the highest attorney in the state government. Here, that is clearly the Attorney General's office. And to Judge Winokur's question, I think the Attorney General absolutely has authority that the statewide prosecutor doesn't. I don't think our system would work if the Attorney General could appoint someone who had power that surpassed that of the Attorney General. I think anything the statewide prosecutor has, which has more limited restrictions, such as the...
Well, how about before 1986? Did the Attorney General have independent power to prosecute crimes in trial courts?
I'm not prepared. I don't know that that was...
I'm concerned that they don't... The only prosecutorial abilities, powers that the Attorney General has is through the statewide prosecutor. So in other words, the statewide prosecutor is the primary prosecutorial authority, principal, because the Attorney General does not have independent power to prosecute cases. That was my concern.
I think if the statewide prosecutor is under the Attorney General, any power it has is necessarily through the Attorney General. I mean, the statute says shall appear for the Attorney General. I don't think appear in this means that the Attorney General needs to personally come to court to prosecute a case, but certainly anything done with the authority of...
But it does appear that whatever prosecutorial authority the Attorney General has, it's exercised by the statewide prosecutor.
In terms of the practical effect, does the Attorney General allow the statewide prosecutor to prosecute the cases? Sure. The problem is that Congress is we're only talking about who can approve the wiretap. So really, I mean, as from a practical perspective, really what would change if this court agrees with the argument and follows the argument here is that when the statewide prosecutor wants to get a wiretap approved, the Attorney General needs to sign off on it. And I think that shows the need for the political accountability, not to get too in the weeds of the political subdivision, but Congress wanted it to be to whoever's politically responsive. And by the state's definition, the statewide prosecutor is one step removed from political accountability because the Attorney General is the one accountable to the voters who can pick and choose the statewide prosecutor. And if there were to ever be a dispute between them, statewide prosecutor says, I want this wiretap. Attorney General says, no, I don't think that's sound. What the Attorney General says goes. And I think that's really how we can tell that the Attorney General is the one who controls.
Can I ask you again about the good faith exception? I'm looking at 93407, and maybe I missed it in your briefs, but my understanding was you were arguing the Kraft case and that there wasn't, good faith present here. I didn't see an argument that there was some statutory exclusion for suppression. Where is that located, and where was that argument made?
That's from, it was in the initial brief as well. Those in Daniels and Giordano talk about the remedy there. Kraft was really more for the proposition that the good faith exception is a judicial remedy, which doesn't apply here because of the Daniels and Giordano, and the Daniels discussion of Giordano, which talks about both the state and the federal remedy.
Well, and Daniels from the Supreme Court was before Leon, that was in the early 80s, right?
That's
and
correct.
Leon was 84, so.
Since then, in the initial brief, I think Rivers would have been after the creation. I believe that also talks about suppression. And certainly since then, I mean, the federal statute, which ultimately controls, hasn't changed in a meaningful way in that time. And I will waive my remaining 10 seconds. I ask this court to reverse.
Thank you. Court is in recess.
All rise. Is there a bucket for the water?